To finish out this chapter, we're going to discuss corporations and limited liability companies, or LLCs, and a couple of doctrines pertaining to them. And as I mentioned before, this chapter doesn't go into detail on all the different types of business entities there are. There's professional corporations, limited liability partnerships, S corporations, which are becoming a more popular option these days. So what's going to be on the test is going to be what we've had time to cover here and in the other videos. But if you do have a question about those, any form that you've heard mentioned or that you read in the book, just feel free to shoot me an email. Now, before I get into corporations, I want to do a recap of what we talked about with partnerships. A partnership, remember, everything goes directly to the partners, kind of the same way it does with a sole proprietorship. So if the partnership incurs any liability, then that, to satisfy a judgment on that liability issue, we can go to the individual partner's personal assets. We can collect the judgment directly from them as individuals. So there's no liability protection there, and that's partly because they haven't really formed anything legally. You know, to start a partnership, all you really do is just start doing work as partners, and then we have rules about how to sort of divide up the responsibility and benefits between those partners. But then also the taxes go directly to the partners, which that can be a good thing. You just file one tax return, and the partnership doesn't pay taxes itself as a separate entity, and then you pay taxes. It's just one tax return. It's just all put into the revenue you got from the partnership is all a part of and any losses a part of your individual tax return. So not having a liability shield, that's not a good thing, but only paying one tax, only paying taxes once, or single taxation, that's a benefit of partnerships. So we've got a benefit, and then we've got a detrimental aspect, which is this exposure to liability as an individual owner in our personal assets. So that brings us to corporations. A corporation is treated as a distinct legal entity. It's treated as basically as a person that can sue and be sued, and can sort of file its own paperwork and has its own responsibilities. It used to be rather a bigger deal to go about forming a corporation. It's a lot easier now to go about incorporating one in your state, but it still does come with more formalities in terms of how it's organized and how it's managed than what we've talked about so far with a partnership, or even a limited partnership, or an LLC, which we'll talk about shortly here. So you can see some of the things you have to go into forming a corporation when you file the Articles of Incorporation. One of the things that has to be addressed that isn't addressed with other forms is the kind of stock that's going to be issued. Stock is what represents the ownership in the company, and the shareholders, of course, of that stock are the owners. And each state, again, has a statute that tells you what to do and how to do it, and it has certain requirements, like naming a board of directors, for instance, and enacting bylaws. These are things you don't have options about, which is one of the reasons it's just a more could be a little bit more burdensome than forming other entities. So with a partnership, for instance, the board is basically just the partners. You don't have to have a separate class of owners and then name a board of directors as well. Or even draft bylaws. It's a good idea to have a partnership agreement, but you don't have to, because we have default rules that will settle any disputes if they come up. Here's just an example of one. You can see some of the questions that are asked. Again, it's a distinct legal entity. It's treated like a fictional person. Unlike what we talked about with partnerships, remember with the two partnerships we talked about a dissolution and a winding up, and that's because those are not considered to have perpetual duration. When the ownership changes, that's considered basically an ending of that present business, and so we have to wind up the affairs, and then we come out of it with a new structure, basically. Corporations are deemed to have perpetual duration, and you probably have some idea of this. When the ownership changes in a corporation, there's not this big winding up period that's done. So, I mean, you may own a corporation yourself in part, or you may someday, in that you may be a shareholder. You might buy some stock in Apple or Microsoft or whatever else, anything on the public stock exchange, and that makes you one of the owners. You may just own a very, very small fraction, but you're a shareholder. And if you sell off that share, everything just keeps moving on. It's not deemed to be an ending to that current structure. That's why it has perpetual duration. So this is just a basic structure that you have to put together to form a corporation. Again, this is what makes it more formal than what we've talked about. And as you'll see with an LLC, you have the shareholders at the top. These are the owners of the company. And this could be a small corporation where the shareholders are just a small group of people, or it could be quite massive, as you know it is with a public corporation where the ownership or the equity of the company is sold on the public market, and so it can have quite a few shareholders. And you can also have different different types of shareholders, and this is something you put into your articles of incorporation or into your bylaws. And so you can have some non-voting shares, you can have voting shares, and categorize it that way. And then, of course, you have to name a board of directors, and I think most states, ours does, I believe, it has some meeting requirements that they have to meet at least once a year. So you have this requirement to have a board of directors, and then they have to meet once it's incorporated, and then at least once every year. And in your bylaws, you'll define how often you want to meet more than that, because you, of course, probably will want to, whether that's quarterly, every 3 months, or every month, if that's what you want to do. So the board of directors are the managers at the top of the management structure. The shareholders aren't necessarily managing the business. They're just as you are with stocks that you own in Apple or Microsoft. You're not really managing the business day to day, but you do have voting rights, even though those votes in a massive corporation, as a small shareholder, if it's a really minority vote, you're not going to change the structure of Apple. But if you did have enough, then you could, and shareholders, or like any other owners, have the right to the ability to change the structure of the business. But in day-to-day matters with a corporation, the board of directors, or not day-to-day matters, but other matters besides changing the structure of the business are made. Big decisions are voted on by the board of directors. And then the board of directors can't be there isn't there every day managing the business. So they, of course, hire the chief executive officer, or at some organizations that might be called the president. At some colleges, it's called the dean or the chancellor. This is the person who is there every day from 9 to 5 or whatever's called for. And they call the shots, make the executive decisions on a daily basis. And then you can see there below them, below the CEO, they delegate. They have their own chiefs of different departments where they delegate some executive decision-making authority to each of those departments. So you have the CFO, the chief financial officer. Except for really major financial decisions, he may not go to the CEO every time he makes a call. He's tasked with making executive decisions in that area on a daily basis. So again, you see the relationship of the parties spelled out there and what they have the rights to do. You'll have shareholder meetings with advance notice given where the owners get to take a vote. You can vote by proxy if you're a shareholder, which is kind of like having a power of attorney for that particular purpose, where you can send somebody else to the meeting to vote on your behalf. Before you can take action at a board meeting or with shareholders, you have to have something called a quorum, which is the number of people that must be present in a voting body before you're allowed to take a vote. So there's going to be a requirement spelled out in the bylaws as to how much of a vote you need to carry the day for a certain decision. So you might, it might be majority rules for most decisions, and then it might be a 2/3 vote for certain serious decisions. And for things like selling off the company or changing the structure of it, you might require unanimous votes for some things. But a quorum is the number of people that have to show up for whatever that number is. So maybe 50%. It's 50% of people present who will carry the day for that decision to be made. So not everyone has to be there necessarily, but of the people who are there, we need a majority of those people to vote in favor of something to pass it. And a quorum is what tells us the minimum number of people that can be present before we can take a vote. Just like with partners, there's fiduciary duties with the board of directors, obviously, to not engage in self-dealing and to be forthright about things that would, not act in a self-interested manner. You see some more things there about what the bylaws will spell out, how often the board is elected, how often they meet, how often and how votes are taken. And so this gets me to probably the most important point about a corporation based on what we've talked about right now. The board of directors and the managers of the business. In a corporation, unlike a partnership, you do have a corporate shield. A liability shield. So, in general, the board of directors, the managers of the company, they are not liable for things that go wrong in the company that cost money. So somebody in the business makes a mistake, somebody gets injured, they were negligent, and now somebody's owed $1 million for some injury. Well, that can only be paid, and the only proper defendant in most cases is just the corporation itself. So whatever the name of the corporation is, the legal name, that is who's actually going to be represented as the defendant, just like it was an individual person that could sue and be sued itself. And so what that means is the managers have this shield of liability, and so do the owners, to where if something goes wrong, their personal assets can't be reached. And this is a good thing about corporations. So this is also why you see when a corporation is having serious financial difficulties and it looks like they're about to collapse, a lot of times the managers will start being paid these massive bonuses, sometimes called golden parachutes, ostensibly because they're getting bonuses because they're doing such a great time in a time of crisis, even though they may have not been doing such a good job, or that's what I should say, a good job in a time of crisis. But that's ostensibly what it's for. But remember, whatever big fat bonuses are paid out before the lawsuits are settled, in most cases, whatever you've managed to get into your personal bank account, that's going to be shielded from liabilities of the corporation. And so this is an advantage of a corporation. The disadvantage of a corporation, though, is that with taxes, corporations have to pay, just like an individual person would, corporations pay their own taxes. And so this gives rise to double taxation, which is, as you can see, gives us a disadvantage compared to a partnership, but it gives us an advantage compared to a partnership because of the liability shield. And also, because of this double taxation issue, this is also what affects some corporations, or all corporations, I suppose, their decision as to what state to incorporate in. And I believe Delaware has some pretty favorable tax rates for corporations, and I think South Dakota doesn't even have a corporate tax of any sort, and so I think that's becoming more popular for corporations to incorporate there. Particularly when you do business all over the country or all over the world, it doesn't really matter which state you incorporate in. And so you're going to choose the one that gives you the most favorable tax advantage because of this double taxation problem. The corporation's taxed, and then the monies of the managers and shareholders, those are taxed on their own personal tax returns. Now, this gets us to the business judgment rule. I said that they're generally not liable, and that's true that's true even if they've made some bad mistakes that cost the company a lot of money. as long as those mistakes made um, were made in good faith, essentially um, towards trying to push the business's profit motive. Um, so even if it turns out to be a bad decision, they're generally going to be still still enjoy that liability shield as long as there was some reasonable basis for making that decision, even if it was a risky one, and it was made, otherwise in good faith. And you can see some of the reasons for this. One of them is that, as with everything in life, the reward is often commensurate with the risk. So, like if you're gambling, you go into the casino and you play the penny slot machines. No matter how much you win, you're not taking hardly any risk, so it's not really ever going to make any difference. And even if you hit it big, you're just going to end up with a bunch of change. But of course, if you go to the blackjack table with tens of thousands of dollars, if you do really poorly, then you've lost a lot of money. But if you do really well at the blackjack table, it's going to pay off in a way comparable to how much you were willing to risk. So we need people in business to be able to take risk, and we don't want them to be afraid as managers and a board of directors to take risks on new innovations, because that's where we get the greatest innovations a lot of times, and also the greatest profit for the business and for the shareholders who are hoping that the managers are going to make them some more money. Also, as noted on the slide here, shareholders know that there is a risk, as you do if you buy stocks on the stock exchange. So it's not an unknown possibility that you could see your shares suddenly drop overnight because of some decisions that were made. The other thing is to capitalize on some of the best deals or some of the best opportunities for a business. This is true of life in general, I think. You often have to act very quickly and without the optimal amount of knowledge. So that kind of that's an inherent part of the risk that comes with making these decisions. And so we don't want people to be judging them in hindsight, because hindsight's 20/20, when they wouldn't have been able to capitalize on a decision without making a decision maybe with less than perfect knowledge at the time. Again, the fiduciary duties, remember those with the directors of the corporation. But also, there's a whole string of cases, there's some evolution to this under the law as to what a corporation's purpose has to be. And it would, originally it was more important that a corporation had a stated purpose in their corporate charter, and they were supposed to stick within that purpose. But long story short, we've gotten to the point where the only purpose a corporation has to have, that the directors have to be chasing, is to make a profit for the shareholders. So that means, it's not, if a shareholder's not going to be able to complain because, a beer business decides to start a clothing line, and that wasn't the original intent of the business. If there's a reasonable basis to believe that could add value to the ownership, to the shares of the business, then as long as they were acting reasonably under this business judgment rule, that's the only purpose that a corporation has to have, is to make a profit. So you see these are not all of them. These are a few more examples of different some other entities that are out there. Again, just if you have any questions about those or any others, just send me an email. They're not going to be on this particular test. All right, this gets us to the limited liability company, or the LLC. This is the most popular right now. I believe it still is. It has been for a while, a couple of decades, more than a couple of decades even. And you see this all the time. If you look at small the small businesses in your town, you're probably going to see LLC by their name more than anything, and that stands, again, for limited liability company. Now, these were created in the 80s, and have become very popular ever since. And they were created in response to some of the things that we've been talking about. We talked about, again, partnerships compared to corporations. They each have an advantage and a disadvantage that the other one does not have. So a partnership, again, no liability shield for the owners, but they enjoy single taxation. The partnership isn't taxed separately. Corporations, on the other hand, if you're a shareholder and the corporation gets itself into some sort of lawsuit, you're not personally liable. Your assets won't be taken to pay for that. However, the corporation is taxed separately, so you have double taxation. You may be paying certain corporate taxes in the state, on the corporation's paying those on its own tax return, and then you're paying taxes on your income tax return. This is why the LLC was created. The LLC combines these two, combines what's good from each of those entities and leaves out the bad parts. So with an LLC, you get that corporate liability shield, and you also get single taxation. So the LLC is not taxed separately from its owner. And so this works just like with a partnership. If you're an LLC owner, you just have to file that one tax return and put the profits and losses into your own individual tax return. So again, this is why it's popular. The other reason it's popular is that it's extremely easy to form. It's basically, I think in every state, well, I don't know what every state does, but in South Carolina, and I think in many others, it's just this one sheet of paper. You put in a little information about who is, particularly who's going to be the registered agent for service if someone needs to get legal documents to you, the address, and the name of the LLC. And in South Carolina, I think you pay a fee of like $125. And that's pretty much it. You don't have to, even though you get this corporate liability shield, it's nothing like a corporation. You can organize it in other ways, but the most you have to have is one person. So in that way, it also can function somewhat like a sole proprietorship. You don't even have to have partners. It can just be one person can start an LLC, and this is why it's easy to form. It's also something to watch out for because it is a very easy way for people to legitimize an otherwise illegitimate business. To most people, it looks like if you have LLC by their name and you can show them LLC certificate, that it means a whole lot, but it's very easy to do, and so people can kind of open and close these a lot who are doing, who maybe aren't the most legitimate business people, and that's why they're opening and closing businesses a lot. Here's some things you'll see in what are called the Articles of Organization to form an LLC. One of the things that's addressed is whether the LLC is going to be a member-managed or manager-managed LLC. What this means is the owners of an LLC are called the members. So if you had just a one-man LLC, it would be a one-member LLC because there's one owner. And you can have separate managers that are separate from the members or the owners, but you don't have to. So if you're going to act sort of like the shareholders of the LLC and you're going to have separate managers, you just have to state that on the LLC. But they don't have to be separate. You can manage your own LLC. You come up with like a partnership agreement. You can do one if you want to, but you don't have to. Here you draft an operating agreement if you want to. But you don't have to. Again, it can just be you doing business by yourself, and that's all the agreement you need. Unlike a corporation, LLC does not have perpetual life. So you basically go through that dissolution process again. Here's a little slide to help you compare. The only thing that's not on there is the LP, which is we've also covered, the limited partnership. Okay, lastly, I want to talk about a second theory here. I talked about the business judgment rule. Now I want to talk about something that can counter that situation, which is called piercing the corporate veil. And I think it comes up with LLCs plenty because they're so easy to form. So the reason you have this liability shield when you form a corporation, or in the case of an LLC, is because there is a formal acknowledgement of this entity that is separate from you. And so that's why you enjoy this liability. We'll treat it like it's its own person. And so that way, if the business does something wrong, it's just the business's assets that will be used to pay for it. Now, I should note here, as I'm thinking about it, because an LLC can be formed so easily, if it's just one person forming an LLC, you'll probably effectively lose the liability shield, because anybody doing business with you, like your landlord or any other contracts you have, they're probably going to want you to sign your contracts. They're probably going to want you to sign your contracts as an individual co-signer with the LLC, so they won't let you sign it just in the LLC's name. In which case, if you sign contracts and you give a personal guarantee on them as a co-signer, then you will be personally liable. So, as we talk about this, it's something to keep in mind. If your business is not much separate from you, you might kind of, in practice, not really have that liability shield. You will have it legally, but not in other situations, but not on your individual contracts if you signed personally on them. So the reason, again, for the shield is the separation, which means that if you do not actually keep a separation between you and the entity, then we have this theory called piercing the corporate veil, where somebody may still be able to go after your personal assets by going through this veil of a corporate structure. And this happens in two ways, basically. One, where, again, there is no real separation between the business and the owners, or if you're using the business to perpetuate fraud or other wrongdoing on other people, we won't let you get away with that, because that's not what it was intended to do. So I've actually seen people do this before, and it can be hard to sue them because of this, because it's hard to find them and know what entity to sue, where they'll open an LLC, they'll defraud some people, and then they'll shut the LLC down and skip town, and there's no more entity to sue, and then they do business somewhere else, and they open a different LLC each time. And so you can look this up in the Secretary of State's website, actually. If you can see what people have done with their business, not just when they started it, but if they shut it down, if they've changed its name a bunch of times. Might make you, in some situations, a little suspicious if they keep changing the name they're doing business under, and so on. So fraud is one way we can pierce the corporate veil, and then again, no separation between the business owners and the business itself. Now, this can happen in a bunch of different ways. Basically, when you start a business, you want to do everything you can to kind of indicate that it's its own person, its own entity. So just like a person's got to have money to walk around with and buy the things it needs. At a minimum, you got to buy food. You got to pay for certain things at the end of the month, and so on. So, likewise with an LLC, if it's undercapitalized, if it never has any money in the business account, then you're not really treating it like it's its own person, because it doesn't really have any operating funds. So let's just look at a case here where this happens. It's kind of a combination fraud and a situation of not really treating it as a separate entity. So the Nugents are a couple who owned a series of roofing companies throughout the years. They had Russell Nugent Roofing, Inc. It was just him and his wife who were the shareholders, the directors, and the managers. Then they changed the name to On Top Roofing a few years later. Then that company ceased doing business. Then they did business through a new corporation called R&R Incorporated. Then that business ceased to exist. Then they opened up RLN Construction. Then that was replaced by Russell Nugent Inc. And that business, I guess, is where we get, or no, this is On Top Roofing was the original, I guess, became the defendant in this lawsuit. But his business, basically, he didn't keep it separate. It wasn't really a separate business entity. So he did a couple of things here. One, they were paying themselves salaries of over $100,000 each. Okay, and he was running it out of his home, and he was charging the corporation nearly $100,000 in rent for some space in his home. So he was using it like it was a corporate expense, which became another reason for him to take an extra $100,000 out, which ultimately went where? There's no other landlord that it goes to. It just goes to him. He's the landlord. Casey Roofing Company here, the plaintiff was owed $45,000 for some roofing supplies that was sold, I guess, when he was doing business as On Top Roofing. And they get into this piercing the corporate veil doctrine, which is ultimately why he was held liable. He's doing it, they focus here mostly on the fraud. He keeps changing names, but he's also keeping it undercapitalized, it sounds like, by draining, I don't know how much money him and his wife made, but if they're each paying themselves a $100,000 salary and they're charging $100,000 to, for rent to this business, they're probably draining most of what they had that year. And so that business account probably wasn't holding, it was probably undercapitalized. Another thing to keep to keep up the separation is to make sure not only that there are separate accounts, but that everything, if you're doing business as the business, then it needs to be noted on everything that that's who is representing that's who is making the promises and committing themselves to the obligations. So you want to do everything you can to, of course, not to commit fraud, but also to keep up this legal distinction between not just the names of the business and the owners, but also the way that you're functioning. You have to function in reality as separate entities. So the last part here in the book, it talks briefly about franchises. I'm just going to give you a brief overview of just how this works, and we'll just kind of leave it there. Just a franchise agreement is one where you have a business that's already established and has established themselves as a successful business, and you're a small business owner and you want to borrow their business methods. Now, for a lot of reasons, you can't just copy, what they're doing. You certainly can't use their trademarks, like McDonald's, for instance. So you have a licensing agreement whereby the franchisor allows you to use their business model and all their materials and their products and to market under their name and use their goodwill. And as a franchisee, you'll have your own separate business, but doing business under the name of this franchisor. That's obviously the benefit of it, because, for instance, McDonald's has a lot of franchisees that are, a lot of the stores you go to are owned by franchisees. And if you go up to the drive-through window when you're walking in the door, if it's a franchise, you usually see a little sticker on the door that says this McDonald's owned and operated by Mom and Pop LLC or something like that. And that's indicating there's actually a separate legal entity than McDonald's, and you'd end up suing that LLC, and you'd probably still sue McDonald's because they have the deepest pockets, but you'd have a separate entity to sue. And so the benefit is that a small business owner gets to benefit from all of the expertise of the franchisor. The downside is, well, one, it can be very expensive to get into. You usually have to front a lot of money to even begin. And then also they have the right to, under the licensing agreement, to control aspects of the way your business runs. So if they want to change a special on the menu, then you're going to have to change it. If they want something marketed in a certain way, you're going to have to abide by, whatever it is you've agreed to in the franchise agreement. So there's some benefits there, and of course some drawbacks in being a little bit restrained by the franchise. And then lastly, I'll just note that there are some requirements from the Federal Trade Commission about things that a franchisor, a potential franchisor, must disclose to you before it does business with you. And you can see some of the things there. One of the important things is they have to tell you every other franchisee that they have, including the ones who have gone out of business. And that can be important to know, especially if they're all in your area. Then that might be a sign that that's not the right, that McDonald's is not that popular in your town, or whatever the case may be. So it's just important to remember that there are these requirements of certain disclosures that are made. And if you hear these commercials on on the radio. I hear them on satellite radio a lot of times. They'll be advertising some business opportunity. One was to sell frozen yogurt. One was to sell blinds for windows. And they'll always say at the end, this is not an offer to buy or sell a franchise. Those offers must be made through the franchise disclosure document. And that's because they want to make sure to not run afoul of those rules that require before you get into these discussions, you've got to make certain disclosures. So that's where we'll leave it for chapter 12, and then we'll go on to chapter 14 next and discuss the basics of agency law, and then we'll start to get into employment law after that, and then that will pretty much wrap up our semester in those last couple of chapters.